This is a case that's been bounced around back and forth throughout the court system.
And today, the Supreme Court has answered that question by a vote of 6-3.
The right to keep and bear arms shall not be infringed.
Everybody has a right if they're a responsible adult.
The court that just changed everything. If you carry, if you train, or if you believe the Constitution still means what it says, then what just happened at the Supreme Court changes everything. A 6-3 decision has redrawn the map of American gun law and rewritten how states are allowed to treat your rights. From concealed carry permits to training rules, from background checks to constitutional carry, the entire framework has shifted overnight. This ruling is not politics, it is precedent, and it affects every responsible gun owner in all 50 states. Please hit the subscribe button, and let's walk through the 10 new rules that now define the future of the Second Amendment, because what you do not know could cost you when it matters most. Chapter 1. The 6-3 decision that lit the fuse. The Supreme Court's 6-3 ruling dropped like a shockwave through every corner of firearms law. The case centered on whether states could force law-abiding citizens to prove special need or endure endless delays before exercising a right guaranteed by the Constitution. The court's answer was clear: no. In doing so, it reinforced and expanded the 2022 Bruen precedent that requires all gun regulations to align with America's historical tradition. The decision reaffirmed constitutional carry as the national standard for lawful citizens. Any law demanding proof of personal necessity is now on unstable ground. The court again used historical practice as the key test for legitimacy. Bureaucratic permission slips can no longer be used to burden fundamental rights. With this decision, the Supreme Court reminded every state that the Second Amendment is equal in strength to the First and the Fourth. It is not a conditional privilege, it is a permanent guarantee. Chapter 2. May issue permits are fading fast. Before Bruen, states such as California, New York, and New Jersey operated under may issue systems. Even if applicants passed background checks and completed training, local officials could still deny permits at will. That era is ending. This ruling dismantles the discretion that allowed officials to pick winners and losers. New York's good cause requirement has effectively collapsed. California's local sheriff approval model is now under serious review. Hawaii and Maryland's restrictive approaches are being challenged. Courts must now look to historical analogs, not modern political preferences. States that cling to subjective systems face a legal countdown. They must rewrite their laws or face dismantling in federal court. For gun owners, this means your rights should no longer depend on your ZIP code or your sheriff's opinion. Chapter 3. No more endless delays. For years, anti-gun states used time itself as a weapon, stretching permit approvals for months to discourage applicants. That strategy is now under constitutional fire. The court ruled that the right to carry is active and immediate, not something that can be postponed by bureaucracy. Courts are treating excessive time-to-permit delays as direct violations of the right to bear arms. States that drag applications for 6 months or longer may face injunctions. Federal suits have already been filed in Illinois, Massachusetts, and other states. Judges are fast-tracking compliance orders to force timely processing. The clock has become the new battleground. Every day a lawful citizen is kept waiting is now viewed as a day of rights denied, and that will not stand under this precedent. Chapter 4. Mandatory training under constitutional fire. Training is essential for safety, but governments have long used mandatory courses and high fees as hidden barriers. The Supreme Court examined whether those conditions could legally restrict access to carry rights, and signaled that they cannot. Modern training mandates are being tested against the founding-era history. Courts are rejecting laws with no 18th or 19th century equivalent. States like Maryland, Connecticut, and California face direct scrutiny. Costs, range hour requirements, and multi-week classes are being challenged. This does not mean training loses importance. It means the government cannot transform instruction into an obstacle. Responsible ownership is a personal duty, not a state-imposed toll booth. Chapter 5. Background checks must be efficient and fair. The ruling did not abolish background checks, but it placed new limits on how they are used. The court made clear that the process must be fast, accurate, and non-punitive. Delays caused by technical errors or indefinite pending statuses now risk violating the Constitution itself. NICS checks lasting beyond 3 business days are under review. States that layer additional screening systems face legal challenges. Gun store holds based on vague suspicion may be unconstitutional. Waiting period extensions in states like California and Washington are being re-evaluated. The message from the court is simple. The system must verify disqualification quickly, or step aside. Justice delayed is now rights denied. Chapter 6: The Collapse of Training Mandates. For decades, states have relied on mandatory training laws to limit who can qualify for concealed carry permits. But this new Supreme Court ruling has shattered that foundation. The court has made it clear that excessive prerequisites, even if presented as safety measures, cannot stand when they burden a constitutional right. States like Maryland and New York currently require up to 16 hours of training and live fire demonstrations. These could now be ruled excessive. California's multi-step process involving multiple classes, renewals, and in-person certifications may soon be rolled back. Courts are already reviewing whether training mandates can be recommended rather than required. The legal standard now demands that any precondition must have a clear historical foundation to remain valid. This decision does not reject training itself. It rejects weaponizing training as a gatekeeping tool. The right to self-defense cannot depend on a class schedule or a $1,000 course fee. The message is simple. The Constitution does not wait for permission slips. Chapter 7: The Future of Background Checks. This ruling has also reignited the debate over background checks. The court did not strike them down, but instead redefined how they must operate under constitutional law. The question now is whether modern background systems, often slow, duplicated, or politically influenced, have any grounding in historical precedent. Some justices noted that the founders never required citizens to pass government screening before exercising a right. Extended waiting periods that delay lawful purchases are now being viewed as unconstitutional burdens. States with multiple overlapping checks may face lawsuits for redundancy and obstruction. Federal waiting period policies could face review if courts determine they delay lawful access without evidence of public benefit. This marks the beginning of a wider legal movement. Gun rights attorneys are already preparing cases arguing that these systems, while well-intended, have evolved into instruments of delay rather than safety. The court has now handed them a powerful precedent to challenge that reality. Chapter 8: Federal versus State Who Has Final Authority. One of the biggest constitutional questions raised by this case is about control. When state laws contradict the Second Amendment, who has the final word? The court's majority made that answer clear, that constitutional rights are national. They do not stop at state borders. States that continue to enforce restrictive gun laws risk immediate federal injunctions. Federal courts are now prioritizing challenges to conflicting state statutes under this new precedent. Even federal agencies, including the ATF, are being evaluated through the same historical tradition lens established by the Bruen line of rulings. Any government entity, state or federal, that attempts to narrow the Second Amendment will face strict scrutiny moving forward. This is more than a power shift. It is a constitutional rebalancing. For decades, states like California, New York, and New Jersey have tested the limits of regulation. Now, those same states are finding the federal judiciary standing firmly in their way. Chapter 9: Bruen Reborn. The 2022 Bruen decision was already a turning point, but this new ruling transforms it from a precedent into a doctrine. Every Second Amendment case going forward will now begin and end with the Bruen test. Does the law align with America's historical tradition of firearm ownership? The ruling strengthens Bruen by making historical justification a mandatory requirement. States can no longer defend laws based on modern fears, crime rates, or political arguments. Courts must now look directly to the original understanding of the Second Amendment. The result is a higher legal bar that will invalidate countless restrictive laws nationwide. This decision has effectively created a new era of constitutional analysis. Bruen is no longer just a standard, it is the backbone of judicial review for gun rights. Any modern rule that lacks direct historical roots will struggle to survive. The balance of power has shifted permanently toward the individual citizen. Chapter 10: What comes next? The impact of this ruling will not stop in the courtroom. It will ripple through legislatures, agencies, and advocacy groups across the country. The conversation about gun rights has now moved from if to how far. Lawsuits have already been filed in more than a dozen states using this decision as their foundation. Pro-Second Amendment states are moving rapidly to expand permitless carry and preemption laws. Gun control states are regrouping, looking for new strategies that can withstand constitutional challenge. The ATF's future actions, especially on classifications and enforcement, will now be watched closely under this stronger standard. This ruling is not the end of the fight. It is the beginning of a long campaign to rebuild the meaning of the Second Amendment under its true original form. The Supreme Court has drawn the line. The next battles will determine who has the resolve to defend it. The fight has only begun. The Supreme Court has spoken. Rights do not wait for approval, and the government no longer holds the presumption of authority. It must now prove its case. For decades, lawful gun owners have been on defense, responding to new laws and restrictions one by one. But today, the ground has shifted. If you believe in real reporting, verified legal updates, and a deeper understanding of the laws that shape your freedoms, subscribe now and stay informed. New battles are coming, new precedents are being written, and for the first time in years, the momentum is on the side of the Constitution. Stay sharp, stay legal, and as always, stay free.